till or.
or
Then
civil.
any land that has been previously been reserved or roadside land or for grazing of cattle or for other public purpose or has entered into the land from which he has been excluded by general or special order, whence further there is no bona fide claim. So this portion which was brought in 1997 includes a portion which comes within the fold of a wasteland.
Well, correct.
Earlier to that, if you see, the law pertains to only previously been reserved roads
Hello.
or roadside land
Hello.
or for grazing of village cattle. Now tell me whether those lands can at any point of time be settled,
That cannot be said.
but whether the wasteland can be settled.
Correct.
Have you thought about that?
This aspect of the
Not preparing properly. Mr. Roy Chaudhary, this is not how you argue a matter when a
wasteland
particularly
can
a
be-
reference matter.
this wasteland can be looked into, my lord, by the
You
government.
see, therefore, you are arguing on the fortuit. You are not concerned with the fortuit. Fortuit will happen. Yes, a squatter, a person who under no circumstances could have entered into
Hello.
the common land. Yes, he has to be thrown out. There is no quarrel with the proposition. There, the notice is not required. But can you apply the same for wasteland?
No.
And is it in your case, taking the brief of the petitioner, that it is the wasteland?
My lord, in the merit of the case, my lord, on the merit of the case, it was not a wasteland. It was a government park.
That is the wasteland.
That's true, my lord. It was,
Have you seen the definition of wasteland?
my lord, that
Read it. Where is it? One to be.
one, my lord. Includes estate includes to be.
Yes.
Well, it is true. That aspect of the matter, well, that wasteland, it cannot be done because in the amendment it has said, as because in 18.2, my lord, it has said, my lord, about the right of the proprietor, landowner, settlement or such as a previously reserved road or roadside land or for grazing land or any other public.
So, reserve road, the question of encroachment does not arise.
But it does not have.
As regards grazing land,
My lord.
in view of Jagjeet Singh, what is that
My lord,
judgment?
2011.
11 SCT. 11 SCT.
11.
What's the name?
Japal Singh.
Jaspal Singh. You cannot
My lord.
get a settlement and you cannot be there.
Right.
As regards roadside, and the third category is this land
Roadside land, grazing of village cattle or other public purpose.
or other public purpose. Just for example, a land has been specifically allotted for the revenue department's office.
Right.
You
Right.
cannot encroach.
Right.
You are to be thrown out on the basis thereof.
Right. Right.
So you don't
As
require
regards
notice.
wasteland, my submission is that, my lord, if a person is entered into a wasteland, after all those lands were excluded, in a wasteland, he is entitled to get a notice.
Why?
My lord, because he has been staying over there for such a long period. He has been allowed to construct. He's been there.
Allowed to construct? Who has allowed you to
My
construct?
lord, but the government knows, man. The government knows that I have been staying over there. And I have been staying over there for such more than 20, 35 years or 30 years. Now suddenly in a first land, they come and say that you are removed from this land on the very first.
But we are not challenging that provision. The provision has not been challenged.
Well, the provision has not been
Then
challenged.
how does this court now do that?
Malad, we are on the reference of that. Two judgments are there. One, that of 2006, which says that notice is not required forthwith. And 18.1 JLR, Malad, it requires that. In 18.2 also there is a notice to be required. But 2018 judgment does not has taken into consideration 2006 judgment. So in one way, it is a par incurable judgment.
But we are not on the aspect as to regards the per incuriam or not.
Because the reference was made.
We are, yes, that might be said. But the question before this court is as to whether notice is required under Rule 18.
18. As because
So you need to differentiate why.
Malad,
Why a notice is required for wasteland,
that
where
is-
is not.
that was my first submission where, Malad, in a government first land, I have been staying there for more than 30 years with the knowledge of the government. And
That
suddenly-
cannot be. Why? They give an answer
they
to the
have not
why.
evicted,
Because you have made a construction.
Malad, or not a
Then what do you
construction.
say? What do you say about Rule 15?
Settlement of occupied lands not included in any deed. No person shall have any right to settlement merely because he is in occupation of a land not included in any list granted to the state government, either to himself or any other person. Here it says about right, Malad. I am not saying about right. I may be thrown out, but given an opportunity to at least some days that you are allowed for this days to remove your things from that land.
Why?
Because Malad,
Because you have a house.
it affects
Although you
my
couldn't have
livelihood.
done that.
Malad, it strikes to Article 21.
Article 21 says
Because
what?
I with my family.
Then why not? If Article 21 is there, why not for the other lands?
Because other lands, my lord,
It's still there.
those lands, my lord, are roadside land or reserve land. It has to specify, but it has not been specified for caste land.
Then Article 21 doesn't come into play there.
My lord, because there, my lord, it is for grazing purpose or some public purpose or for some other requirement is there. That is why the government.
You
will-
may not know
because,
whether it is for public purpose.
my lord,
You may not know. Is it for public purpose? Then why not a notice
my
to
lord,
intimate you?
my lord, for public purpose, if suddenly they evict me in a without a notice, they come and throw me out of a land. I've been staying over there. At least, my lord, to make me know that yes, this is for a public purpose. You have to go ahead. That much is requirement in a
So then also you are saying that for public purpose also notice is required.
no man. I won't
Then-
say for public purpose notice is required. Not. Then, my lord, if public purpose also, my lord, in a land acquisition case, if it is for public purpose, it is required. 4, 5, and other things come into play. But here, my lord, if suddenly I have been staying for more than 30 years in a government task land, suddenly somebody comes to me and throw me out of that land. At least 15 days.
Because you know it. It is always presumed that you know the law.
my lord, ignorance of law is not an excuse. Correct.
So under such a Rule 15 categorically says you cannot.
my lord,
Rule 16 says that you can, provided the DC gives you a permission.
my lord. So,
Then
you
how
are-
do you do, how therefore you come into that you are entitled to a notice?
So your lordship is in the view that, my lord, maybe it is a task
I am
land.
not of the view, I am only asking you.
My lord, my submission with your lordship, if a person stays for a considerable period over a plot of land. 18th of the-
Yes, Mr. Advocate General, how do you differentiate both?
Yes,
Because you see-
section 15, section 14 and section 18, we have to read together. That gives a very clear picture. There is no ambiguity in which situations notice is required, in which situation notice is not required.
No, there is
Is that-
no ambiguity. But how do you bring in the whatever actions you are taking under Rule 18 is an administrative action.
Absolutely.
If it is an administrative action, yes, those lands which you cannot settle. On the other hand, if you see the land policy, you categorically mention in more particularly in 14.4 of the land that look here, those people, we still hold it that the land policy of 1989, we have given some assurance out there. Those people who are staying out there, we will consider till 2001, we will consider them to be settled. to give a settlement. How do you take care? How do you interlink both? That on one hand, in respect to the wastelands, you allow somebody and you will give them a settlement, and on respect to somebody, no.
That situation will come in each individual case. What is the situation? In suppose there is a requirement of settling the erosion affected persons. Government have the right to settle it. In those situations, the cause is different. Here in this case, it is they want settlement, or he is in the presumption that he will be settled in the village grazing ground. He is not very clear in his petition also. That is not permissible.
No, no,
And
village-
if we have to settle him in that village, then alternative in lieu of that, another plot of land has to be given. But he is not challenging the provisions of the law as it is existing as on date, Lordship. We have to go by that.
Understood. But how do you take care of an administrative action, and more particularly of the development of law of Article 14 in regard to proportionality?
If he challenges 18 on that
No, not
ground,
necessary. Why can't we read the principle of proportionality into Rule 18?
his initial action is illegal.
I'm not on that.
Illegal. Void ab initio.
Mr. Advocate General, kindly appreciate. We are not on the question as regards the petitioner. We are not going to decide the petition. We are only on a set to deal with a reference for which
Absolutely.
this
The
bench
three
has been
issues are
constituted.
before the Honorable Court.
So wouldn't it be a case of proportionality to be looked into? Yes, those lands like grazing ground, no, he cannot. Roadside reservation, there might be. Forget about that. In wastelands also, just for example, today, you evict them, but following a due process. Then tomorrow he again comes in. No notice is required. Then for that to say that in wasteland you require notice may also be wrong. But the question involved out here is as to whether you can just say that nothing is required for anything, or you are not going to decide to look into any aspect of the matter. We want to just throw them out.
It is not that he did not know about the eviction process. He knew. Formal notice is not given to them. In Silsaku, when we evicted, everybody came to know that in 1 week's time or 10 days time we are going to. And there was announcement also.
The Kilhago is another exception, taking into account it is a water body.
Here it is a VGR.
Again, Mr. Advocate General, we are not on the question of VGR. We are question of as to whether in terms
Yes,
with
if
18
the
a notice is
legislature at
required.
that point of time, when the amendment was brought in 1997, what are the areas, what are the types of land included?
You brought in
Government
everything.
has land, wasteland, and the estate over which no person has acquired a right of proprietorship, landholder or settlement holder.
So you bring everything. Now everything is brought within
And it was
India.
put to challenge, and it was never interfered by the Honorable Court. It was put to challenge. I have all the judgments. I'll place it.
No, understood. But that was not interfered. Okay, there's no quarrel with that.
Lordship.
That there was no interference. But
Now, why?
but
they
can
have
we
done,
say-
why they have done it selectively? As an advocate, I cannot say that selectively we do. Whenever there's a requirement and whenever it has come to the notice of the government is taking steps now. How we are clearing the Satra lands, how we are clearing the forest reserves. In Hujai also, he's near his own place. The petitioners, I'm saying. Same thing is happening in Hailakandi, that inner line reserve forest. Same thing is happening in various places in Arunachal border for reserve forest. And Goruputi Lordship knows it very well. Those were not reserve forests in Goruputi. We have cleared
No,
everything.
again, bringing into the aspect of reserve forest, there cannot be a settlement.
There cannot be a settlement.
Because
But
it
there is
is-
illegal encroachment.
Understood. For that, you can throw them out. Where those land can be settled, how do you take care of
And in
that?
some cases, when there's a overwhelming public interest or really their requirement of land, the land policy also covers that for resettlement. In this case, is not for resettlement.
Let us see the land policy.
Situation like that. Page 81 in our
Huh?
dossier, we have submitted list of cases as well as the land policy at serial number 10, page 81 to 99.
You have it then.
Yes. The recent one of 2019, page 81.
Yes.
Various categories are there.
What do you say about 14.4?
14, settlement and reservation of land in town. No land within the municipal corporation or town constituted under Assam Municipal Act and town land declared under the Assam Land Revenue Reassessment Act 1936 shall be settled for agricultural purposes. Now explanation 4234. 4 is, however, in view of the land policy of 89 and other government decisions prior to adoption of this land policy, the cases of indigenous landless person, if found eligible and who have been under continuous occupation of government land since or prior to 28 June 2001 may be considered for settlement of maximum of 1 katha 5 lessas in case in Guwahati and 1 katha 10 lessas in case of other towns as one-time measure for homestead purpose if they apply for it, irrespective of having land in rural areas subject to realization of due premium. Whether he has done that or not, that is not a consideration.
We are not
But
concerned.
that we are doing it, Lordship, under various.
No, understood. This very person, you have a policy there.
We have a policy.
But this very person can also be selectively thrown out because he under 18.
Here, it is not that he cannot apply.
No, no, he
His
can
case is
apply.
totally different.
But are you saying?
Suppose he has applied and he may have other land also. Every individual case has to be looked into the special facts and circumstances. Now, his case, we are not in the reference. But the thing is that if he has already land in other places and also occupying these 2 kathas of land, whether the notice will be required or not. Number one.
Mr.
And
Advocate
number two-
General, if I was sitting in the single bench on that day, that is the more particularly the date on 18/2/2022, that day would have been the final death knell of the writ petition. I would have dismissed it right away because he was in the VGR land. That is not the question before this court. The court out here is as to whether in an 18/2 proceedings you require a notice.
18(2) proceedings,
In a-
we do not have to give notice. 18(3) we have to give notice. The law is well settled. It is no more res integra. And by division bench of this honorable court,
Let
several
us-
division bench judgments are there.
Let us
Therefore, this is a reference in my humble submission was not required at all by the learned single judge.
No,
Because-
if we consider that the division bench order is wrong,
No, no,
we can
he
do so.
considered another case of the learned single judge.
Understood, but if we consider that the division judge order requires reconsideration, we may refer it to a full bench. Don't worry with that.
And
we
to
can
that
do-
effect, we have the Supreme Court judgments of Radha Kanus and all.
Radha Kanun, no, the Advocate General, kindly see, Radha Kanun came prior to the 97 amendment.
Radha Kanu 2005, if I'm
No, no.
1996.
19.
Sitting in bench 4-5 for a long period, I got accustomed with it.
Malad, Equal Lordship, subject to permission. In my a repetition, so it is not under reference. The grazing land was de-reserved and it was already settled with some other person. That is why I came before this court saying that please, if you have given settlement by de-reserving that grazing land.
Mr. Advocate General, we will give you time, but we will hear on the question of proportionality. Because
Doctrine of
another
proportionality-
thing, because what happens? Now you have to look into, yes, those judgments which were given, then it's a different thing. But whether there are two aspects, one on the notice and should we? There might be some
No,
check.
if suppose in a division bench lordship decides that notice is required in 18.2, that will be rewriting the legislation.
No, we are not writing it.
It will be, it
It-
will
it-
amount to,
it is
because the
not
language
required.
is so clear.
Not required. Don't read it. We can very well, on the basis of proportionality, bring in the concept of a year for those purposes. Or you may
Nah,
be,
I will address on doctrine of proportionality.
yes, on the doctrine of proportionality, on the basis that when the government takes an action or an administrative action, the
proportionality
government
comes
has
when
to
there's a
see the
challenge.
least affected.
I understand, Lordship, but the doctrine of proportionality comes when there is a challenge to the law.
No, not necessary. Not necessary. Doctrine of proportionality in Media One was brought in by the Supreme Court out here. There was no challenge to the
For
law.
administrative action, it is
On-
very difficult because the officers will have to follow what is there in black and white.
For that, we can very well read it, and then we will later on, if you don't follow it, we have to set aside such actions. Don't worry.
Provided there is a challenge. But there is no challenge now.
No, we will hear to that aspect
I'll
on the
address, okay.
question
Yes.
of proportionality, because you see, yes, we make it very clear out here. As regards those grazing lands and all these things where you cannot grant a settlement, you can throw them out. No, you
Direct violation of justice.
absolutely. So you can very well throw them out. As regards those lands.
No, we can settle,
But not
provided we have another plot of land in lieu of that land, we are declaring that land as a
that is
VGR.
that is a
That
policy of
option.
the government. That's a policy of the very well thought of policy that they will, instead of throwing them out, we will give them rehabilitation in some other thing. We are not on that.
No, the
But
VGR.
whether on the
Suppose this VGR, where he is staying, suppose we declare that is, we are withdrawing the notification of VGR. Then identical same measurement land in another location, we have to reserve it for the VGR purpose. That is also permissible. But that is not the policy of the government at this stage in respect of Hojai. So I'll definitely address if that is the query. The Lordship may indicate in the order what exactly Lordship wants my address on the proportionality, on what part, so that it will be easier for me to prepare and make my submission.
The instant reference arises in view of an order dated 18/2/2022 by the learned single bench, by the learned single judge, in the instant writ petition, wherein, in view of a conflicting opinion in two division bench and two single bench judgments, a question as a reason as to while exercising whether the authority, the revenue authorities, while exercising the powers under Rule 18.2 of the settlement rules under the Assam Land and Revenue Regulation 1886, for short the regulation, would require a notice. We have taken into account the provision of Rule 18.2 and also read the same in conjunction with Rule 18.3. From a perusal of the settlement rule, from the perusal of sub-rule 2 of Rule 18, it apparently shows that there is no mention of any notice. On the other hand, a perusal of sub-rule 3 specifically mentions of a notice of 15 days. This we have also taken note of that prior to the amendment carried out to Rule 18.2, on the basis of the amendment made on 29/3/1997, the exercise of the powers under Rule 18.2 was specifically in respect of land. Do you have the old act?
Yeah, in the with compilation manner.
The lands which were the land specifically dealt with reserve roads, land previously reserved for roads or roadside land, or for grazing of village cattle, or for other public purpose. Or had entered into possession of land from which he has been excluded by general or special orders. However, with the amendment carried out, additionally, lands which are government cast land or wasteland or estate over which no person has acquired the right of a proprietor, landholder, or settlement holder, or any, were brought within the fold of Rule 18.2. Therefore, after the amendment, all lands falling within the ambit of the regulation comes within the ambit of Rule 18.2. The only bar to exercise the power, therefore, under Rule 18.2, if there is no bona fide, if there is a bona fide claim of right involved. Therefore, a question arises. As to what lands the government is presently granting settlement, inasmuch as regulation, inasmuch as settlement inasmuch as sections 32, 33, 34, 35, specifically deals with the power of the government to grant settlement in respect to wastelands. The settlement rules which have been framed in terms with Section 12, and 29 of the regulation specifically deals with the power of the government as to how the settlement is to be made in terms with the above mentioned provisions of the regulations. We have also taken note of the land policy of 1989 as well as the land policy of 2019, wherein the government had envisaged their policy as to how settlement could be made in respect to the lands which now specifically falls within the ambit of Rule 18.2 after the 97 Amendment. Therefore, while hearing the matter, this court has specifically put a pointed query upon the learned Advocate General appearing on behalf of the state of Assam as to whether the principle of proportionality, which is a facet of Article 14 of the Constitution, could be brought within the fold of the can be applied to Rule 18. And also how the state would distinguish in view of their specific policy, land policy of 2019, as to whom to grant the settlement and whom not to grant the settlement. And thereupon take an action under Rule 18. Another question which duly comes, another query which have been put to the learned Advocate General as to if no notice is given, how the authority would decide as to whether there is any bona fide claim of over the land. More so, when the only ground remains now, only bar remains now, after the amendment in 1997 in respect to all government lands, is there, if there is a bona fide claim over the right. When
After we will take it up.
did I put too many questions?
Not too many questions, because there are too many other cases fixed during this. Even today, there are 3 matters in 3 special benches. Hmm? Okay, ma'am.
Yes. When
এখনো direct No.
yes,
Maybe Lord
our Advocate General is busy.
30th of June, 30th of April, 30,
303.
Tuesday.
Okay. List the matter on 30th of April 2024 for further consideration. We will bring another rule 34 agote, eta ago 32 agote rule section 34 agote section 12 and 13 nu bhorai di.
It's there.
Press list, my lord. I'm instructed to not to press this matter, my lord. We may be allowed to. 1/8 of this.
Just 1 minute. Huh? We'll take up the FAOs first. Okay. I'll just say most of the FAOs I could see out there are all have become infructuous.
In my case, also.
Yours is item number
1/8.
18 FAO 7. Huh?
Yes.
How can you say it to be infructuous?
Not exactly infructuous, my lord. Party
It is the plaint has been returned.
return, my lord. Not
Then?
exactly infructuous. The party is not interested to pay. I mean,
No, we'll take it up. The first FAOs, I'll take it up first. You are there?
My lord, the item 6 and there are 2 FAOs, my lord, in fractures, my lord, because
Yeah.
mains-
No, let me pass those orders.
No.
We'll take up this FAO. So, take up it.
may I please, your lordship?
Item number 5 to
this matter, Lordship might not like to take up. Item number 5.
no, item number 5, this thing, the suit has already been disposed of, decreed.
Lordship, I'm not aware as on date.
But not by me. I think I was the lawyer.
Yes,
Okay, list the matter before any other.
I'm up.
It is otherwise infructuous. Item number 6.
6 and 7, my lord, both. Main suit has been decreed, my lord, in the meantime on 18th of April 2017.
Item number 6 or like 6 and 7 different. You need- These appeals, 6 and 7, these appeals arise out of an order dated 13/5, no? 6 and 7.
Yes,
Okay.
13/5.
13/5.
13/5 to 13.
Very good. These appeals, both these appeals are taken up together for disposal. Both the appeals arise out of the order dated 13/5/2023 passed in Mizek.
2013, madam.
Huh?
2013.
Understood. 13/5/2013 passed in Mizek case number 83/2012 and Mizek case number 84/2012 in title suit number 25/2012.
Sure.
In the meantime, the said suit has already been disposed of by the judgment and decree dated 18/4/2017.
Lord.
Under such circumstances, both the appeals has become infructuous, for which the same stands closed. Item number 13 to the instant appeal arises against an order dated 8/11/2013 passed in Mizek case number 50/2013 arising out of title suit number 10/2012. The said suit being title suit number 10/2012 have already been disposed of by the judgment and decree dated 3/8/2019. Under such circumstances, the instant appeal has become infructuous. As such, the instant appeal stands dismissed as infructuous, has become infructuous, and as such, the appeal stands dismissed. The registry shall return the LCR to the court below. Item number 14. Item number 15. Who is appealing? Ako naman. Kuma. 17.
What to take up after 2 weeks, when I take me get the instruct.
No. Matter has become infructuous.
Matter has become infructuous.
Because you see, the date of birth of the person
Now
is 18/8/2004. And now
now
she's,
more than 18 years.
so nothing remains.
Technically,
Mr. S. Bora, the learned counsel appearing on behalf of the appellant submits that the word the submits that the order, impugn order, dated 2/7/2014 in Miss Guardianship case number 24/2010 pertain to the custody of the minor. Full stop. The date of birth of the minor is being 18/8/2004 and as on date, the said minor had become a major. Under such circumstances, in that view of the matter, the instant appeal stands closed as it had become infructuous. The LCR pertaining to the instant appeal and the LCR, the registry shall forthwith return the LCR to the court below. Yes, 18.
I have the instructions not to praise this.
Mr. A. Samoa, the learned counsel appearing on behalf of the appellant, submits that he has instructions not to press the instant appeal. Accordingly, the instant appeal stands dismissed on withdrawal. Interim orders, if any, stands vacated. 19,
Has also become infructuous. It's also been
suit has been decreed.
Ordinance has already been decreed, my lord. The dismissed, my lord, as against which they have also preferred an appeal, my lord. First appeal before
But
this.
this doesn't remain.
My lord.
Continue. The instant appeal arises out of an order dated 25/11/2014 passed in Mize case number 886/2013 arising out of title suit number 323/2012, whereby the application seeking injunction was
Yes,
rejected.
Rejected, my lord.
It has been informed to the court that the said suit have already been
Dismissed, my lord.
dismissed
On the 2nd of the August 2019, my lord.
by the judgment and decree dated 2/8/2019.
Right.
Consequently, the instant appeal had become infructuous and accordingly stands closed. The registry shall return the LCR to the court below.
Right, right.
20. Twenty-one. Yeah, আগৰ অৰ্ডাৰটো নিচিনা দেই হা খালি নিচে কেছটো হ'ব 485. You are there.
21.
It has become infructuous.
Matter has been settled out.
No, understood, but the suit has been decreed, dismissed or allowed.
Dispose of all settlement will outside the court.
It has been compromised. No, it was withdrawn. The suit was withdrawn. You withdrew the suit, I remember. This is an application. The instant appeal arises out of the order dated 22/3/2016 passed in Mize case number 485/2014 arising out of title suit number 432/2014. Pustak. It has been informed to the court that in the meantime, the said suit being titled suit number 432/2014 have been withdrawn. And accordingly, the said suit has been closed by an order dated 22/8/2022. Accordingly, the instant appeal has become infructuous, for which the same stands closed. Yes, 25.
Hello.
Were there?
Yes.
What is the why you are asking? Yes.
My lordship, it's an FAO and it's on the issue of there's a patent. We have the patent and on that basis, kindly come on page number 4 of the petition.
What are you challenging?
Yes. Challenging page number 86. We have filed this case for suit for declaration of title and interest, and that case is pending before the Kamro District Court. And page number 86, the main operative portion of the District Court order is on the second last para. May I read for my lordship?
Page.
Page 86.
Yes.
Second last para, fourth line. But in annexure number C, there is no stipulation what are the terms and conditions of the agreement between the petitioner, plaintiff number 2, with Sumotec Innovation Private Limited, nor there is any authority letter from the petitioner number 2 to institute this case by petitioner number 1 or on behalf of petitioner number 2 with regard to the contract between the opposite parties in the year 2021. My lordship, now this is a patent issue. Patent was earlier in the name of appellant number 2, Mr. Girish Manohar Rao Bachate.
Where is your plaint?
Plaint is page number 13.
Yes. You are the plaintiff.
We are the plaintiff.
What is your prayer? Relief sought for.
Relief is given on page number 34. So we are the manufacturers of the smart meters, and there is the
Declaration that the plaintiff's right, title, and interest the effect that the plaintiffs are the lawful holders of the patent number 2081 for the technology.
now there is an infringement on behalf of the opposite parties. Now we have filed this case, and on that case only, as per the order dated 20th September 2023, our case was not allowed on the basis that we don't have the right to file this case. But we have been assigned this patent. Assignment agreement is on page number 87. In fact, page number 90, sorry, my lordship, page number 90. Read of assignment is on page number 90. This patent was earlier in the name of Mr. Girish Manohar Rao Bachate. Later, it was assigned in the name of Sumotec Innovation Private Limited. This is a proper deed of assignment, and it was well accepted by the Controller General of Patents, Designs and Trademark. That is given on page number 93.
Let us see
Right.
page 91.
Page 91.
The assigner that is the person,
Yes.
is the applicant in respect of patent application as mentioned below.
Yes.
Has he been assigned the patent? He has been given the patent.
He has been given the patent.
Where is it?
That is on page number page 87. Page 87, the patent certificate is there.
Certified that the patent has been granted to the patent.
Bachate Girish Manohar Rao. Kindly check the page number 88 also. That is the legal status of the patent. And in that, the name of the grantee and the patentee. And kindly check page number 89 also, where the patent has been rightfully assigned in the name of Sumotec Innovation Private Limited. Page number 89, somewhere in the middle, name of the patentee.
And you are the assignee.
We are the patentee as of now. Assignee is now Mr. Girish Manohar Rao Bachate. He has assigned the patent in our name. My lordship, once the patent has been assigned in our name, we have all the rights as per the section 68, 69, 70 of the Patents Act to file each and every case. And this is as per the official website.
But why in 2022 there is no mention about this document at page 87?
Page 87 is the patent certificate that was given in 2004. That's the
Then
final.
why in 2022, why there is no mention that you have been granted a patent to the assigner?
In 2000, because it was granted in 2022 only. That's why it is mentioned in 2000. It takes around 1 year for all the process
Mr.
completion. and all.
Counsel, are you understand?
Yes,
Page 87 is a document of 2007.
yes,
Okay. Now this document in the year 2022, page 90,
page 90.
your entire right arises from this document.
Yes.
Why there is no mention about this document, the patent certificate in this document?
Patent application number is mentioned, page 91.
Patent application is mentioned, but there is
Page
no
91.
mention about this particular document. Why? It could have been very well mentioned about this document.
But my lordship, patent application number is mentioned. Kindly check page
No,
91
no,
for a minute.
therefore kindly see
Yes,
grant. What is the grant? For an amount of rupees 1,000, which the assigner acknowledges to be good and valuable concern, the assigner hereby transfers the right, title, and interest in the patent application and in the said invention to the assignee to hold unto the assignee absolutely forever. Now the assigner undertakes to execute all documents necessary to record this assignment in favor of the assignee and assist the assignee in recording this assignment at the patent offices of all other world of if required. Now, whether anything done as per 2.2,
my lordship.
whether anything has been done in terms with point 2.2,
Page 88 and 89, that has been done.
has anything been done as per 20?
Kindly check page 89. There is a proper assignment. It has been accepted by the Controller General. Page 89, somewhere in the middle, name of the grantee, name of the patentee. So patent has already been granted in our name. Additionally, Mr. Girish Bachate is also a party in this case as well.
No, where is your name here?
Somewhere in the middle, Sumotec Innovation Private Limited,
Where?
page 89.
89.
Now, this is the legal status in force and the due date of next renewal is 13/5/2024. It's officially accepted by the Controller General. Kindly check the last page, page 93 also.
No, understood. But why there are two different things? You say
Because the
both
legal
our
status
patent number
prepared
is
every year.
208216, page 88
Page 88,
is 208216.
208216.
And you see the name of the grantee and the name of the patentee
Yes,
is the same.
yes, yes.
Okay. Now,
Because this was the status before
thereupon,
the
the
assignment deed.
same thing,
This was the status before the assignment deed. Now the status was changed as per page 89. This is the current status.
so this was changed when?
This was changed after this assignment deed, and the assignment deed is the dated of
22.
2nd September 2022. And this takes around 1 year. This whole process takes around 1 year. That's why in page number 89 it is mentioned. And page number 93 also it is there. Kindly check page number 93 also. Again, the legal status.
Now, what has happened in the meantime? As of now, do you have the patent?
We have the
How?
patent. We
It
have-
is for 20 years?
It's for 20 years, it's till 13th May 2024,
No, if you see here, page 89,
page 89. My lordship.
third year, fourth year, fifth year, sixth year, and the 28th year ends on
Yes.
30. Due extension, due date with extension is 30/11/2023.
Yes.
Then
The-
after
the
that,
last
20
date
years is gone.
13th May 2024. The patent was granted on 13th May 2004. From that date, it is 20 years.
So their 20 years will be finishing
13th
on
May
13/11/2023.
No, 13th May 2024, that is the due date. Due date with extension.
Renewal period is till
This is every
13/5/2024.
year. Every year we have to renew the patent. That's why it's written here. But the final date is for the 20 years. Kindly check the patent certificate on page number 87. Date of filing is 13th May 2004. And on that, in line number 3.
It
Line
is
number
given
3,
for 20 years from then.
30th May 2024, page number 87. Kindly check.
Mhm. So when
Let me
will
read for
the
my lordship?
13/5/2024?
2024, the 20 years are going to complete it.
So thereafter, there is no patent.
Thereafter, there is no patent.
Okay.
Yes.
Now let us see in that. Now here he says locus standi, there is no locus standi. Why? Let us see what is the reason given by the trial court.
Page number 86, the operative portion of the trial court order. Second last para.
We will go, let us see. The plaintiff present. So on the ground that you did not have the authority from the petitioner number 2 to institute the suit, the application was rejected. That's it.
Yes, but the honorable court committed a grave error in deciding the locus standi. First of all, the original patent holder himself was a party in that case. And he is a party in this case as well, this appeal as well. He is the appellant number 2. Second, once the patent has been assigned to some person, he is the holder of the patent. And the only authority that can decide is the Controller General of the patents. That is there, which I have shown on the page number 87, 88, 89, that it has been assigned in our name. As per section 68, 69, 70 of the Patents Act,
So why you are not approaching the controller general then?
we
if he
need
can
not
decide
approach, they need to
everything?
approach.
Huh?
We need not approach, they need to approach.
Why?
Because we are the holders of a patent now. If they have any issue with our assignment, only they can approach. Why should we approach?
No.
As per section 68, 69, 70 of the Patents Act, once the patent has been granted to some person or the authority or any company, and that has been registered in the recordal of the Patents Controller General, they are the holder of the patent and they can have all the rights. They can even assign to other person.
Why didn't that petitioner number 2 sign the wakalatnama in that suit?
He had,
Then in that circumstance, why it has been said that you did not take the authority?
there was no need to say this. That's what the main case is. He himself was a part of this case. He is the part of this case as well. He is the appellant number 2 here.
Yeah, he filed the wakalatnama. Yeah, wakalatnama kontra.
In any case, although he is a party, but even there is no need of him being a party. But he is a party. The Vakalatnama is there.
No, there is no wakalatnama here. How did you file? There's only one wakalatnama of R1.
We are the petitioner.
Huh?
We are the petitioner.
So how many?
They are the appellants.
There's no two appellants.
2 appellants, yes.
Who are the two appellants?
Somotech Innovation Private Limited, that is given on page number 2 of the petition, and page number 3, Girish Manohara Bachate.
Where is his wakalatnama?
I think it's a single Vakalatnama.
No, it can't be. Only one person has signed. There's only one wakalatnama.
That is R2 is their part.
Huh?
R2 is
R2 is their party.
the appellant.
Mr. Mukherjee, there is only one wakalatnama. That is of under the sign and signature of that Sumtok something.
Somotech
Sumotech
Innovation Private
Innovation.
Limited.
Then how did you file on behalf of him? That must have been the problem. Why will the other court do? Otherwise the court would do that.
Page number 13, the title suit is there. There also he is the party to that case.
Whether he has signed the wakalatnama there.
Yes, sir. Yes, he is a party to that case. As per-
Mr. Counsel,
Yes.
you are saying he is a party out here in the appeal also, but there is no wakalatnama of his. If this be so, the same must have been done out there.
Yeah.
Then?
Yeah.
Then what is wrong with the trial court's order?
No, even if he is not a party, my lordship,
Huh?
it has been assigned. He need not be a party in each and every case. It
Then
is
why have you
assigned.
made him a party?
I agree. It was added as a party and there is some issue with the wakalatnama. He will check his.
No, there is no issue of the wakalatnama. You have made somebody a party who has not signed the wakalatnama.
My lordship,
There is no power also. Not only that, there is no power of attorney also has been taken.
but in the order, the court has mentioned petition number 1 and 2 both. That means obviously he must be there. If the court has mentioned plaintiff 1 and 2 in the order. In that case, he was wakalatnama must be there.
Your submission I would have otherwise accepted. But that submission cannot be only ground I am not accepting, because on the face of it, here also you have not filed the
I-
wakalatnama. We dismiss the appeal on that ground. What is wrong?
My lordship, my lordship.
This is not the
Kindly,
case.
kindly check page.
And your
kindly
period
check
is
the
ending.
order.
You are asking for damages. You'll get damages. 13/5/2024.
but
Your
my
period is ending.
But we are the party in this case. We cannot get the damages since we are the party. We are the
The
holder of
suit
the
has not
patent.
been disposed of.
Suit has not been disposed.
Well,
but
you are
for
the
the
assignee. You see the agreement. You see, kindly see page 80 and 90. Page 90 out there. You are supposed that person, the assigner, undertakes to execute all documents necessary to record his assignment in favor of the assignee and assist the assignee in recording his assessment so and so all over the country. Where are these documents?
Kindly check section 68, 69, 70. It is to be checked by the Controller General.
Then go to the Comptroller General. Be happy.
We
Yeah.
need not go to the control.
You are
Kindly
asking for,
check page-
Mr.
section
Counsel,
68.
if you are asking for damages, the trial court will grant you the damages out there. If
but-
necessary, you fulfill that prayer of bringing that wakalatnama
But
out
the
there.
trial court has decided wrongly on the basis of the locus standi. That is my issue here. Kindly check 68 and 69 of the Patents Act.
No, the court has looked into only one aspect, that there is no wakalatnama of the person concerned there. You filed only the wakalatnama of Sumote. If you have not done it here, there also the same thing.
No.
There is no wakalatnama, only of the respondent number 1 is there.
But obviously, my lordship, the honorable court must have checked. That's why they have mentioned the
I
respondent
have
number
checked,
2.
that is why I mentioned it here to you.
Here, it may not be there, but in the district court, it is there. In the district court, I am talking about here. That is the only point I'm making. And in any case,
I can do one thing if you want. I can call for the records. Nothing more than.
Yeah.
And by the time I call for the records, your 13/5/2024 would be finished.
what the damages have been done, so we'll get the damages. There is
That is why, if you are therefore I am saying, if it is a case of damages, why don't you go and go ahead? Why should this court now interfere? That there is nothing, no wrong as regards the petitioner
Because
number
it-
2.
because the locus should be there. That then
As
only
of
we can
now,
go back there.
As of now, what are you asking?
We are asking for the locus because we are the party.
What are you asking as of now in the injunction application?
Injunction application.
What are you asking? Let us see icon.
We are only asking for the observation of locus. I'm not pressing the application also. Only asking this case is about the observation of the locus standi of the honorable court.
I can do one thing, I can dispose of the appeal without saying that this court is otherwise not interfering with the dismissal rejection. However, the locus standi of the area shall be decided at the trial of the suit. You want that?
But locus standi is
Will be decided at the trial of the suit.
kindly call the records. Let there be decided on here only.
How?
Kindly call the records. Wakalatnama must be.
No,
there.
no. As of now, I am also saying that you don't have the locus as regards the petitioner number 2. Appellant number 2, because you have not filed the wakalatnama. There is no power showing that you have the authority to file a suit on behalf of the appellant number 2. I'll also hold the same thing, if that is the same thing.
If that is the same thing there, but We can call the wakalat, we can call the records. That's why what I'm asking, this
Why?
honorable court. Because this Kamrup court have mentioned, they. My lordship, the entire suit will be in practice then.
Mr. Counsel, that is the best order you can get. I will say that I am not interfering with that order. However, and more particularly as the period is ending on 13/5/2024, this court is not ending. However, the locus standi of the suit or the plaintiff's right to file the suit, independent of the plaintiff number 2, shall be decided by the trial court at the trial of the suit. That is the best. You can very well get it because you have the assignee.
You have the, yes.
You being an assignee,
Yes.
you have a right to file a suit if there is any
Yes.
transgression.
Yes.
So that let that be, court decide that aspect. As of now, to interfere now with an injunction would be not in public interest, taking into account something has been. Now you will be entitled to get the whatever claims you can in as regards whatever has been done till now. That is the best way.
Okay. That is fine.
The instant appeal under Order 43, Rule 1R of the Code of Civil Procedure 1908, for short the code, is directed against the order dated 29/2023, passed by the Additional District Judge number 1, Kamrup Metro at Guwahati, in Mizze case number 60/2022.
20th
Mizze case number what?
case number, title suit.
60/2022 or 23?
23. 22.
22?
Yes, 22.
22.
22.
22, arising out of title suit number 02/2022. It is relevant, however, to mention at this stage that in the impugned order, it has been mentioned as Mizze case number 60/2023, which ought to
23.
have been
Yes.
Mizze case number 60/2022.
23.
The said application from the materials on record, it transpired that the plaintiff, that the appellant number 1 and 2, as plaintiff has instituted a suit being title suit number 2/2022, being aggrieved by the actions of the respondents, defendants, in using the patent of the appellant of the plaintiffs. Under such circumstances, the said suit was filed seeking declaration of right, title, and interest in respect to the patent bearing number
208216 patent application. Page
Is
number
the number?
93. 208.
208216. Which was granted with effect from 13/5/2004 for a period of 20 years from the date of the said grant. Yeah, last line too. (13/5). Semicolon. For compensation and damages
From the date of 2004, my lordship, I'm so sorry for interruption. Kindly come page 87. The date of grant is 19/7/2007. It happens the patent takes 3 years. So patent is from 13/5/2004 only. So not from the date of grant, from the date of 13/5/2004. There's just a technical issue. That's why I'm mentioning.
Okay, I'll correct it. Don't worry. For damages and compensation, along with a prayer for permanent and perpetual injunction, restraining their defendants, their men, servants, attorneys, agents, etc., from manufacturing, selling, installing, using or otherwise dealing with the smart meters or products under whatever name, using the technology and process invented and patented by the plaintiff number 2 as prepaid postpaid electricity supply machine under patent number 208216. Along with the said suit, the plaintiff also filed an injunction application under Section 108 of the Patents Act 1970, read with Section Order 39, Rule 1 and 2, and Section 151 of the Code. The relief which have been sought for, the ad interim temporary injunction which was sought for, was similar to the relief of permanent injunction sought for in the suit. The record reveals that the defendants number 2, one has not filed written statement. No?
No.
The defendant number 2 had filed written statement as well as written statement to the in the suit, and written objection to the injunction application. Various preliminary objections were raised to the maintainability of the suit, as well as on merits. The case of the plaintiff was denied. Plaintiffs were denied. Further to that, it is also seen that there was also an additional written statement filed bringing on record further bringing further additional pleadings. The written objection so filed is also states that the plaintiff has not been able to make out a prima facie case for grant of an injunction. And the entire case of the plaintiff, number 1, is based on a concocted story. On the basis of the said pleadings, more particularly the injunction application, the plaint, and the documents so filed, and the written objections so filed by the defendant, number 1, 2. The learned trial court heard the injunction application and by the impugned order dated 29/2023 rejected the said injunction application. In the said order, which have been impugned in the instant proceedings, it is seen that the learned trial court though observe that there is an agreement between the plaintiff number 1 and plaintiff number 2 but there is no stipulation in the agreement as to what are the terms and conditions of the agreement between the plaintiff number 1 and the plaintiff number 2. It was also observed that there was no authority letter from the plaintiff number 2 to institute the instant suit by the plaintiff number 1 for and on behalf of the plaintiff number 2 with regard to the contract between the opposite parties in the year 2021, that is prior to entering into the agreement via Annexure C. On that basis, the learned trial court, without further dealing with the principles for grant of an injunction, dismissed the application on the ground that dismissed the application on the ground that the plaintiff number 1 had no locus standi to file the suit, file the case. Being therefore aggrieved, the instant appeal has been prepared. This court have heard the learned counsel appearing on behalf of the appellant as well as the respondents. And have also perused the materials on record, including the certificate, the patent certificate issued by the Controller of Patents, Government of India, in respect to the patent number 208216. From a perusal of the said application, said certificate, patent certificate, it reveals that the said certificate was issued on 19/7/2007. And the patent was granted to the plaintiff number 2 for the invention prepaid postpaid electricity supply machine for the term of 20 years from 13/5/2004 in accordance with the provisions of the Patent Act 1970. Therefore, from the very provision The said therefore from the said patent certificate, it is apparent that the patent number 208216 granted in favor of the plaintiff number 2 would remain in operation till 13/5/2024. This court further have taken note of that there is a document at page 89 of the memo of appeal, which shows that the plaintiff number 2 have been shown as the grantee and the plaintiff number 1 has been shown as the patentee.
Patent.
It is also seen from the said very document that the 28th year, that for the 28th year, the renewal was made by a renewal certificate number 9658, which was done on 13/5/2023. And the renewal period was from 13/5/2023 to 13/5/2024. This court have also taken note of the deed of assignment Mr. Mukherjee, you have a copy of the list of documents you have submitted before the trial court.
No.
Why? You are not appearing in the trial court. You are appearing in the trial court.
I recently engaged the trial.
And you are appearing out here without knowing anything. As to whether this deed of assignment is the Annexure C document which the court has been referring to, that is what I wanted. Madam, you have a copy of the list of documents submitted before the trial court?
No.
This court further takes note of the deed of assignment dated 25/8/2022.
My lordship, for a small intervention, page 86. This assignment deed must have been part of the record. Kindly check page 86, just for a minute.
Why?
Just for a minute. It
Why?
will clarify everything.
What is there?
Annexure C, it is mentioned.
What?
Annexure C reveals that an agreement has been entered into by petition number 2 with Sumotec. So obviously that deed of assignment.
That is what you see. The court is not mentioning as deed of agreement, assignment.
Yes.
Court has mentioned as deed of agreement.
Agreement.
That
Yes.
is why I wanted to know.
Okay.
But the sad part is both
Whether the same
of you have
document
appeared in
is
the
there or
appeal
not.
without
Yes.
knowing. Anyway, this court have also taken note of the deed of assignment entered into between the plaintiff and plaintiff number 1 and the plaintiff number 2. Dated
2nd September 2022, page 92.
2nd of September 2022.
That is given on page 86 also. the same day.
From the said document, it reveals that the petitioner number 2, the plaintiff number 2, had assigned by way of transfer the rights, title, and interest in the patent application and in the said invention to the plaintiff number 1 absolutely and forever. This has to be therefore taken in the context of the said assignment, however, has to be taken in the context of the deed of assignment being made on 2nd of September 2022. This court have also taken note of that the respondent, you are appearing for respondent number 2,
Yes, yes.
you are now supplying the smart meters in pursuance to some contract.
Actually, I am not the engaged counsel, Your
Okay, you
Honor.
don't know anything.
Yes.
This court have also taken note of that the respondent number 1 and 2 herein had entered into an agreement and on the basis thereof, the respondent number 2 had issued an RFP bearing number II double Roman capital IIPL oblique 21-22 oblique AMI oblique RFP oblique 008 and had entered into various agreements with MS Ashoka Buildcon Limited on 1/4/2022 and by a purchase order dated 1/4/2022. Cyanconode, CYANCONNODE, C2 of second C2 capital Private Limited by purchase order dated 19/4/2022. Snyder Electric India Private Limited by purchase order dated 12/4/2022. And Sinhal Udyog by purchase order dated 12/4/2022. However, it has also been mentioned that a business relationship with MS Ashoka Buildcon Limited had been terminated and the remaining work have been issued to one Purbanchal Enterprise by purchase order dated 16/10/2023. It was also mentioned that pursuant to the purchase orders, the respondent number 2 is procuring the smart meters from multiple vendors and not manufacturing on its own. And the respondent number 2 is merely an implementing agency oblique service provider facilitating the installation of the smart meters. It is also, this court also finds it relevant to take note of the submission of the learned counsel appearing on behalf of the respondent number 2. To the effect that thereby supporting the case of the learned trial court, to the effect that the appellants herein have miserably failed to demonstrate that the product installed by the respondent number 2 fell within the scope of the said patent. She submitted that the appellants neither conducted any infringement analysis nor have enclosed any document to show the infringement of the suit of the patent. It was also submitted that the appellant had failed to demonstrate that the patent is a standard essential patent by failing to provide mapping of the claims of the patent on the standard. Further to that, it was also submitted that the learned trial court may not have looked into the said aspect of the matter, but the strength of the patent needs to be tested before an injunctive relief can be granted. On the question of balance of convenience, the learned counsel also submitted that the patent is going to expire in 3 months, that is on 13/5/2024. 2 months. Less than 2 months. And therefore, no injunctive relief should be granted. In the backdrop of the above, this court, while taking up the order passed by the learned trial court, finds it relevant to observe that the learned trial court rejected the application merely on the basis that the petitioner number 2, the plaintiff number 2, on the basis that there is no documents to show or file, that the plaintiff number 2 permitted the plaintiff number 1 to file the suit. This court had put a specific query upon the learned counsel appearing on behalf of the appellant as to whether the plaintiff number 2 had filed any wakalatnama in title suit number 2 in the state suit. Or any document empowering the plaintiff number 1 to file the suit was filed. Both the counsels appearing on behalf of the appellant expresses ignorance to that aspect. Be it as it may, this court also finds that in the instant appeal, there is only one wakalatnama filed, that too of the appellant number 1. And there is no wakalatnama filed of the appellant number 2. Therefore, the instant appeal has to be construed to be an appeal only filed by the appellant number 1. Therefore, the observations by the trial court, which obviously being prima facie in nature, that the plaintiff number 2 did not empower the plaintiff number 1 to file the suit, cannot be slightly brushed aside. Be it as it may, from the documents on record, it appeared that the plaintiff number 1, or for that matter, the appellant number 1, had a deed of assignment by the plaintiff number 2 to the plaintiff number 1. And in the records of the controller of patents, the appellant number one's name, or plaintiff appellant number one, or plaintiff number name, one recorded as a patentee. Therefore, irrespective of the plaintiff number two being not a have not filed the necessary documents or empowering the plaintiff number one to file the suit, the suit otherwise would have been maintainable so far as the rights of the plaintiff number one. Therefore, the next question arises as to whether the learned trial court should have granted the injunction as sought for. Or for that matter, this court should, did you file any IA out there for grant of an injunction or no? Yes. Or should this court, in exercise of the powers under Order 39, Rule 1 and 2, grant an injunction in favor of the appellant number one? This court have duly taken note of the contents of the claim, wherein the plaintiff number one have sought for various damages. It is also clear from the documents which have been placed by the plaintiff before the suit and which is a part of the instant appeal that the right of the plaintiffs number one at best, appellant number one, at best would be till 13/5/2024.
Yeah.
And as on date, only 1.5 months remain. This court have also taken note of that while the respondent number two pursuant to the tender issued by the respondent number one have issued various purchase orders to various parties who have supplied as per the respondent number two, who have supplied to the respondent number two. It is therefore the specific case of the plaintiff, the respondent number two, that the respondent number two is not manufacturing any meter, but is only procuring the meters from various vendors who should have been made the parties. And the suit being filed without making them as necessary parties, the instant suit was not maintainable. Taking into account the above aspects, this court is of the opinion that the plaintiff oblique the appellant number one, plaintiff number one oblique the appellant number one may have a prima facie case for going for trial in suit alone. Since any document being produced permitting the plaintiff number one to file the suit on behalf of the plaintiff number two. But the plaintiff number one, or the appellant oblique the appellant number one, does not have the balance of convenience in his favor for grant of an injunction in the present facts, as well as The question of irreparable loss, harm, and injury does not arise inasmuch as the plaintiff number one, if is successful in the cause of the suit, can be duly compensated. Under such circumstances, this court is not inclined to interfere with the order dated 29/2023 for the aforementioned reasons. However, this court makes it clear that the local standard of the plaintiff, number one, to file the suit on its own, on the basis of the documents, has to be decided at the trial of the suit. And the observations made in the said order dated 29/2023 to the effect that the plaintiff number one oblique the appellant number one does not have the local standard to file the case should not act as a should not be taken into account while deciding the suit. With the above, the instant appeal stands.
I'm led by senior advocate T.K. Mishra is in this court, item 16. It may be taken up in the next statement.
But why are you mentioning it? It is the mentioner. Don't mention. Yes.
May I please preparing on behalf of Alice. Kindly later make pass for
Why?
because of my senior counsel is not available.
Huh?
My senior counsel is not available.
Who's your senior?
Amistad.
Why is he not able?
Medical emergency.
Hmm?
Medical emergency.
What happened? What I said? At the request of the learned counsel for the petitioner, appellant, matter stands adjourned to be taken up again on 21st. 21st, no further adjournments. I'll get hold of another.
Please, your lordship, in this case, the appellant expired on 16/1/20. You may be allowed.
How are you filing an FAO? And when did the appellant expire?
16/1/24.
It has been submitted by the learned counsel appearing on behalf of the learned counsel. It has been submitted by the learned counsel that the appellant expired on 16/1/2024. So under such circumstances, 16/1/2024. Today is what?
Today is 19/3.
Oh. Under such circumstances, list the matter immediately after the Bihu decree.
Right.
20.
Yes.
May I please? Yeah.
Madam. This is cannot be an FAO. An FAO you pay court fee of ₹10. The court fee has to be as per the suit because it is a dismissal of the suit. So dismissal of the suit, you have to pay the curricular court fee. Thank you. It is seen that the instant appeal have been prepared under section 104 of the code against a judgment and decree passed in money suit number 6/2009. Under such circumstances, the appeal ought to have been filed under section 96 of the code, which would be a regular first appeal. In such circumstances, you have paid the court fee. Nothing. Yes. FAO number 15 of 2014.
My lord.
What is this?
This is, suit was dismissed, my lord, and plaintiff filed suit for damages, my lord. For requisition.
Plaint was rejected under Order 7, Rule 10, returned.
No, my lord, suit on contest dismissed.
Are we referring to FAO number 15 of 2014? Ram Nagina Pandey?
No, my lord, Narendranath Sharma.
Hey, আগৰটো কি হ'ল? এইটো উল্টা হ'ল। Ram Nagina Pandey.
Ram Nagina is
The earlier one, na?
earlier one.
Earlier one. Hey, earlier one to এইটো কৰিব, হা? এইটো। তাত কপি দিয়া আছে। Yes, what is this?
My lord, there's this appeal, my lord, the suit was dismissed, my lord. Suit was for damages, my lord, because of his vehicle was requisitioned in the year 2002, my lord. And year 2005, my lord, the damaged vehicle was retained. On that count, my lord, petitioner.
You are in Narendra Nath Sharma?
Narendranath Sharma, my lord.
Okay. Now the suit was dismissed.
Dismissed, my lord, because, my lord, on the ground of limitation, my lord.
Okay. Then what is the limitation?
My lord, may I kindly peruse? Issue number 3, my lord, at page 34, my lord.
Issue number?
Issue number 3, my lord. Page number 34, my lord.
Yes.
Issue number 3 relates to the question of law of power of limitation in filing the instant suit. Turner government pleader appearing on behalf of the defendant urged that the suit is time barred and the plaintiff suit deserve dismissal. Controverting the above submissions, Turner counsel for the petition plaintiff submitted that the plaintiff had from time to time approached the Honorable Guwahati High Court between the years 2003 to 2009, and the and that in WPC number 68/2009, the Honorable Guwahati High Court by order dated 23/3/2007, directed event number 2 to release the documents pertaining to the vehicle. And again, WPC 4658/2007, Honorable Guwahati High Court by order dated 6/1/2009 had directed the issuance of duplicate registration certificate of the vehicle. Learned Counsel urged that the plaintiff had been prosecuting with due diligence before the Honorable Guwahati High Court has plaintiff's case could be covered by Section 2014 of the Limitation Act, and further vouched that the plaintiff case is within the time. To address the issue, it will be supposed to or refer to the Section 14 of the Limitation Act. Section 14 is reproduced here under for better appreciation. Section 14, exclusion of time of proceeding bona fide in court without jurisdiction. 1. Computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in the court of first instance appeal or revision against the defendant, shall be excluded. Where the proceeding relates to the same matter in the issue and is prosecuted in good faith in a court which is from defect of jurisdiction or other cause like nature of is untenable to entertain it. 2. In computing the period of limitation for any application, the time during which the applicant has been prosecuting with the due diligence another civil proceeding, whether in a court of first instance or the appeal or revision against the same party for the same relief, shall be excluded, where such proceeding is prosecuted in good faith in a court which from the defect of jurisdiction or other cause like nature is unable to entertain it. 3. Notwithstanding anything contained in Rule 2 of Order 23 CPC, the provisions of the subsection 1 shall apply in relation to the first suit instituted on permission granted by the court under Rule 1 of that order, where such permission was granted to the ground that the first suit must fail by reason of a defect in the jurisdiction of the court and other cause like nature. Explanation from the perusal of Section 14 of the Act in deference, it is seen that the section is intended to provide a benign relief against the law of limitation in cases where the party has chosen a wrong forum on account of bona fide mistake, or in cases where the court is incapacitated to grant the relief for want of jurisdiction, etc. In the present case, the plaintiff had approached the Honorable Guwahati High Court by way of filing petition seeking a direction in terms of date of the appropriate authorities for redressal of his grievances. PW1 exhibit 1, exhibit 2, exhibit 3, and exhibit 4 being the certified copies of the order of the Honorable Guwahati High Court in WPC number 3490/2002, contempt petition case number 74/2003, case number 13/29/2005, and WPC number 7319/2004 respectively. Perusal of exhibit 4 discloses that said order was dated 3/1/2006, and it was observed that the Honorable Guwahati High Court under the state order that the plaintiff would take the court to civil court for settlement of claim of sustainable in law. PW1 also exhibited exhibit 6 being the certified copy of the order passed by the Honorable Guwahati High Court in WPC number 465/2007. Perusal of exhibit 3 again discloses that the Honorable High Court, while observing that the petitioner's claim for damages could not be entertained in exercise of jurisdiction under Article 226 of the Constitution of India, did not issue any writ, while observing that
It was not only on the limitation, many other grounds.
other grounds, my lord, basically, my lord, the learned judge held that he has not sustained any livelihood or loss, my lord, due to the non-flying of the vehicle.
Then why are you only concentrating on limitation?
Other parties, my lord, in fact, my lord, requisition part is admitted in the judgment, my lord. And so far as damage part is concerned, my lord, and my lord, I have a sustained damage, my lord. In my plaint also, I have stated, my lord, that fact, my lord. Since my lord 2002 to 2005, my lord, my vehicle was used for counterinsurgency operation, my lord. And during that period, my lord, my vehicle has been completely damaged, my lord.
Where's your plane?
Plate is at my lord page 12, annexure 1, my lord.
Hmm?
Annexure 1, page 12, my lord. 1 to my lord. Relevant is para 5, 6, 7, 8, 9.
So the High Court passed an order to the effect that on 3/1/2006 you were asked to go to the civil court.
My lord.
Then again you file another writ petition.
Because my lord, I have not received any documents of the vehicle, my lord.
But you were
Otherwise, how
asked to go move the civil court.
my lord, because due to the non-receipt
What
of-
was your first writ petition for?
regarding the release of my vehicle, my lord.
And
My lord, accordingly, my lord, I have all whatever was passed to-
and for damages?
no, for damages, my lord, in my petition, my lord, first petition is itself is there, my lord, for damages.
So for damages also. So as on the date of 6/1 to earlier period is okay, 2005 we won. But as on 3/1/2006, your suit was, you should have filed 3 years from there.
My lord.
But you didn't file.
Because, my lord, I have not received any documents, my lord, in the last order of this honorable court.
That is a different thing.
submitted.
That is absolutely different. But as on 3/1/2006, you were asked to file a suit.
I have not filed, my lord, because, my lord, I have not received any documents, my lord. Otherwise, my lord, how I will file, my lord?
If you have not received the document, you are asking for what? You are asking for damages.
My lord,
In the earlier writ petition, you have asked for damages.
my lord.
The same damages you are asking here.
In the subsequent, in the present suit, my lord.
In the
Since,
present
my lord,
suit, you are asking for the same damages.
Because, my lord, in the second petition, my lord, second petition, I have filed because I have not received any document, my lord, since they have given me the damaged vehicle. So otherwise, other documents related to my vehicle, my lord, is not received by. Received
That
by
is
me,
a
my
different thing. That
So
you
in that
can, no, Mr. Counsel, you can very well call for those in the civil court. Those are not a issue. But for the purpose of damages, you have asked in the first writ petition.
Well.
And the court says that that cannot be decided in a writ court and as such go to the civil court
Well.
as on 3/1/2006.
Well.
Thereupon, you did not file the suit before 5/1/2009.
my lord.
So, it's about by limitation.
But, my lord, one thing is that, my lord, say in the second petition also, this honorable
You
court.
can't raise the same thing. The second writ petition, if it is there, can you get the benefit that you are bona fide litigating?
Yes, my lord, because, my lord, I have not received, since, my lord, this honorable court, my lord.
That is not immaterial. Are you not asking for the relief which you sought in the first writ petition in the suit?
Initially, I have not, my lord.
What did
because-
you, what was your prayer in the first writ petition? You have the writ petition?
My lord, I have a copy, my lord, and I
Give it to me. I'll see. I'll record it.
first petition is the exhibit 1, my lord,
See file.
and then exhibit 8.
First writ petition is an order. That he is the owner of Viman and the said requisition, then it is submitted the vehicle is broken and lying around so and a petitioner is now praying that being a private should be requisition. Upon so and so, he is directed to release the vehicle of Viman and the respondent may so and the petitions can dispose. That is on 2002. We are not concerned with that. Then 19 to 2003, we are not concerned. Now this writ petition, we are concerned.
6, 8, my lord.
Exhibit 4. PJ co-stated, yes, petitioner's vehicle is so and so, have been completely damaged. It is under such a way the respondents have filed a petition. He has turned over it. But man, because of as the petitioner was not paid the compensation for the period during which his vehicle has remained under requisition, and also for the damage that was caused to the vehicle, the petitioner has, with the help of the president, sought for appropriate direction, seeking for not only compensation for requisition, but also a direction to pay him the cost of the expenses which are required to be incurred per remand for the vehicle, according to the petitioner, has been wrongly damaged. And then now Iman, what emerges from the above Iman is liable, is that the respondents are liable to pay in all to pay to and so as the compensation for requisition in the byway. As against that, the petitioner have already been paid by way of 261. The balance payment therefore remains. The petitioner does not dispute on account of the requisition, the petitioner is entitled to receive this. Now, have you received this 3,55,000?
Yes, my lord, here this.
Okay. Considering the above, the hearer directed the respondent shall within 3 months to and so will pay. As regards the petitioner with regard to entitlement to receive cost for the complete damage, it is hereby made clear that since this aspect of the matter is intensely in dispute or mere petitioner may take recourse to Iman. So this damages question came here.
My lord.
Then, if that be so, as on 3/1/2006, you were given this period will be taken earlier. You are entitled at that point of time. You got it in 2005.
My lord.
So thereupon, anything else has happened, we may give you the benefit of more bona fide litigating it till 2006, 3/1/2006, nothing further than.
But subsequent read, my lord, this honorable court
You can't keep
also-
on filing writ petition after writ petition asking for the same thing and thereby enlarge your limitation.
But in the subsequent read petition, this honorable court also, my lord, granted me the liberty, my lord.
Understood.
That is,
Liberty would a liberty
Since-
granted. The liberty would be subject matter of a unless in the liberty it has been mentioned that the period during which the instant writ petition is pending is to be excluded. If it is not given, then how do you take the benefit of section 14?
My lord, may kindly peruse 6/1 of 2009, my lord, the order of this honorable court, my lord. That is exhibit. my
This
lord.
court in excellence cannot decide whether the petitioner has suffered any loss or not, and also the quantum of the compensation. It requires detailed examination of it. And this order was passed when? 2009.
My lord. Thereafter, my lord, I
The
have.
claim of the petitioner for damages therefore cannot be entertained. However, it will not preclude the petitioner from approaching the civil court having jurisdiction from the matter of claiming damages. So, the question is whether you have the limitation or not.
In view of the judgment passed by in this, my lord, in 6/1/2009, my lord, I have, there is no limitation. Subsequently, I have filed the suit, my lord.
And you say from there another 3 years.
Yeah.
Now, when did you get the vehicle? 2005.
2005, my lord.
So when was the damages felt?
From 2005, my lord. But my lord, there is no document on me, with me. my
No
lord.
document doesn't help. Well, that cannot be the ground. So who is appearing for the deputy commissioner?
Another thing, my lord,
Yes, madam. Don't see you nowadays taking up bench one. Yes. Yeah, appearing. Your name can be put while
Madam,
dismissing his appeal.
My lord, my lord.
Yes.
Yeah.
my lord, another thing, my lord, another small submission, my lord. In fact, my lord, it may be a continuous wrong, my lord. Since, my lord, from 2002 to 2007, my lord, till filing of this second petition, my last petition, my lord, they have not provided me. First, they have provided me with a damaged vehicle, and subsequently with not, my lord, required document, my lord, for which I have again.
Your vehicle was damaged and given to you in 2005.
My lord.
Thereafter,
That's
nothing.
correct. Into my lord,
Your
the-
damages was felt in the year 2005 when the vehicle was given. You are asking for the damages, the loss which you incurred during the period prior to 2005. The instant appeal arises out of the judgment and decree passed by the learned trial court in Manisut number 06/2009, whereby the suit filed by the plaintiff the appellant was dismissed on various grounds, including the question of limitation. From the materials on record, more particularly the plaint, it reveals that the plaintiff was the owner of an ambassador car having registration number ASL 8372. The said vehicle was requisitioned for law and order by the defendant number 2 on 5/10/2002, but the vehicle was used for counterinsurgency by the defendant for the army. The said vehicle thereupon was damaged by the army and was subsequently kept in Makale Garage, Abhayapuri on damaged condition. Under such circumstances, the plaintiff submitted a letter on 18/3/2003 to the defendant number 3 to repair the damaged vehicle, but nothing was done. Pursuant thereto, the plaintiff filed a writ petition being WPC number 3490/02 against the defendants. And this court, by an order dated 29/5/2002, directed the defendant number 2 to release the vehicle of the petitioner within 7 days from the date of the order, and also directed to make an inventory and determine the compensation payable to the plaintiff to be released within 3 months from the date of release of the vehicle. It was also observed in the said order that if the plaintiff is aggrieved by the compensation, he may approach the defendant number 2. Pursuant to the order being passed, the plaintiff communicated the same to the defendant number 2. And the defendant number 2 thereupon directed the MVI Bongaigaon to assess the repairing bill of the damaged vehicle. The plaintiff, however, was not satisfied, for which the plaintiff filed an contempt proceeding, being contempt case number 74/03. In the said contempt proceedings, this court, by an order dated 19/12/2003, directed the plaintiff to submit the repairing bill to make the vehicle roadworthy, and on furnishing the same, the defendant number 2 was directed to get the matter verified and pay the plaintiff such amount that would be required to make the vehicle roadworthy. On the basis of the said order, the plaintiff submitted the bill to the defendant number 2, which was then forwarded to examination to the MVI and the executive engineer PWD Mechanical Division of Bhayapuri. Thereupon, a report was submitted by the executive engineer PWD Mechanical Division stating an amount of rupees. How much?
32,
What is that 32/35?
35,000.
32,000, there's 32,000, there's 35,000 would be required for repairing of the damaged vehicle. To which, however, the plaintiff did not agree. However, the contempt case was disposed of with an advice to the plaintiff to seek the vehicle to release and dispose of the contempt. Thereupon, the plaintiff filed another writ petition being WPC number 7919/04. And the said writ petition was disposed of by an order dated 3/1/2006 for payment of compensation and also to initiate a civil suit to claim the suit cost for complete damage of the vehicle. It is also stated in the plaint that the defendant returned back the damaged vehicle on 17/1/2005 and paid the requisition bill. Till that period. Be that as it may, it is very relevant at this stage to take note of that pursuant to the vehicle being returned on 17/1/2005, the suit, the writ petition WPC number 7319/04 was disposed of by an order dated 4/1/3106. Thereupon, another writ petition was filed by the plaintiff as the papers of the vehicle was not returned. Being WPC number 6368/06. This court, by an order dated 23/3/2007, directed the defendant number 2 to take steps with regard to the non-release of the documents of the vehicle, and on verification, if it is found that the grievance of the petitioner is genuine, to release the documents without further delay. Subsequent thereto, the petitioner filed another writ petition, being WPC number 4658/07. And this court, by an order dated 6/1/2009, directed the defendant number 4 to issue a duplicate registration certificate in the event the plaintiff makes an application for the purpose and subject to clearance of all required dues, with a further observation that the plaintiff may approach the civil court having jurisdiction over the matter of claiming damages. Thereupon, the record reveals that the plaintiff issued a pleader's notice under Section 80 on 14/2/2009, claiming an amount of rupees 34,20,150. However, the said pleader's notice having not, pursuant to the pleader's notice, no payment having been made, the suit was filed on 14th of September 2010. I'm coming back. Is this the mentioner?
Because
Sorry,
it is the order matter, my lord. So,
we'll take it after disposal of it. Now, pursuant to the filing of the suit, the written statement was filed by the defendants, raising various preliminary objections as regards the maintainability of the suit, and also on the merits that the petitioner, that the plaintiff was not entitled to the compensation as claimed for. On the basis of the pleadings, initially, 9 issues were framed. Thereupon, 2 other additional issues were framed. The said issues, being relevant, are reproduced hereunder. Page 30 or 31 not. 30 a not 31 or 2. It reveals from the records, it reveals from the thereupon, both the sides adduced evidence by the judgment and decree dated 24/7/2015. The suit was dismissed. While dismissing the suit, the learned trial court decided the issue number 1, 2, 4, 6, additional issue number 1 and additional issue number 2 in favor of the plaintiff. Whereas the other issues have been decided against the plaintiff. Being agreed, the instant appeal has been filed. Although, from a perusal of the nomenclature of the appeal, it reveals that it is an appeal filed under Section 100. Although, from the nomenclature of the appeal, it reveals that the appeal was rightly filed under Order Section 96, read with Order 41 of the Code. But it was incorrectly registered as FAO number 15 of League 2016, which ought to have been registered as a regular first appeal. This court also have taken note of that the due court fee have also been paid. In the backdrop of the above, this court have heard the learned counsels appearing on behalf of the petition appellant as well as the respondent. And upon hearing the said counsels, the following point for determination arises for consideration. Whether the learned trial court was justified in dismissing the suit, in deciding the issue number 3, that the suit was barred by limitation. Number 2, as what another issue. This court, in the foregoing paragraphs, in the foregoing segments of the instant judgment, have duly taken note of that the vehicle of the petitioner was requisitioned on 5/1/2002. And admittedly, the damaged vehicle was returned to the plaintiff on 17/1/2005. In that respect, if this court takes note of the compensation which have been sought for in the suit, it would be seen that an amount of rupees 2,07,150 has been sought for as regards the expenses for the damaged vehicle. Semicolon. Rupees 27,03,000 have been sought for on account of the loss of business from the date of requisition of the vehicle till the vehicle was delivered. An amount of rupees 2 lakhs was sought for on account of physical agony, and an amount of rupees 3 lakhs have been sought for on account of mental agony. No, mental or itu na lage. 2,17,150 have been sought for repairing of the damaged vehicle, and rupees 27,03,000 has been sought for loss of business. I go to it. This court further finds it relevant to take note of that this court, by an order dated 3/1/2006 in WPC number 7319/04, have duly mentioned that the petitioner would be entitled to initiate civil action for the claim of the damage of the vehicles. It is also relevant to mention that the loss of 27,03,000 was in respect to the period prior to 17/1/2005. and the loss as regards the loss of the business. A perusal of paragraph number 11 of the plaint reveals that a claim of rupees 27 lakhs 3,000 was made for the period from the date of release of the vehicle in 2005 till the date of filing of the suit. As regards, it is also seen that in respect to the mental and physical agony, the claim of the plaintiff was that he suffered due to non-release of the vehicle in question. At a point of determination, whether it is the suit, whether the learned trial court have decided the issue number 3 in a properly or the limitation, and number 2 as to whether the plaintiff was entitled to any relief in the suit. From a perusal of the plaint itself, it reveals that as the plaint was filed in the year 2010, and the claims made in respect to the damage of the vehicle and for the mental and physical agony was prior to 2005, prior to the delivery of the vehicle in question, which was in 2005, 17/1/2005, the same was barred by the limitation, even taking into account the order passed by this court on 3/1/2006 in respect to WPC number 7319/04. The next question, therefore, arises as to whether the suit was barred in respect to the claim pertaining to the loss of business for the period from the date of release of the vehicle till the date of filing of the suit, which the plaintiff quantified at rupees 27 lakh 3,000. From a perusal of the plaint, the claims so made does not appear to be barred by limitation. Therefore, in the opinion of this court, the learned trial court erred in deciding the issue number 3 in holding that a claim for loss of business of rupees 27 lakh 3,000 was barred by limitation. However, this court makes it clear that the decision as regards the suit being barred by limitation in respect to the claim of rupees 2,17,150 for the expenses of the damaged vehicle, as well as 5 lakhs on account of physical and mental agony, requires no interference. Then the next question therefore arises. The next point of determination therefore arises as to whether the plaintiff is really entitled to any relief on account of his loss of business to the tune of rupees 27 lakh 3,000. This court have duly perused the evidence of the plaintiff and merely by stating, the plaintiff merely stated that he sustained average daily loss of business to the tune of rupees 1,700, which he calculated to be rupees 27 lakh 3,000. No evidence has been produced on what basis the plaintiff claims this amount. Under such circumstances, it is the opinion of this court that the issue number 7, which have been decided by the learned trial court, requires no interference. Consequently, in view of the above, this court finds no merit in the instant appeal, for which the appeal stands dismissed with a cost of rupees 5,000. With a cost of rupees 5,000. Full stop. The registry shall remit the records to the learned trial court.
Obliged.
List item 1.
Yes, ma'am.
You took back the file
Yes, correct.
and then again you deposited again on 6/2/2024. And then also you did not enclose the certified copy.
No, I have misplaced my file. I have stated my affidavit. I have stated in my affidavit, I have misplaced the file.
How did you file the appeal? Without a copy?
It was filed in hurry. Your Lordship.
No, without even, forget about the certified copy, even without enclosing the photocopy also. Why? Even without enclosing the photocopy. How did you file the appeal with a wakalatnama with no signature of the advocate? Understood. Hurry. You took it back on 15/12. Then you returned after 2 months. Then
No, Lordship, I have
you
informed-
returned it on 6/2/2024 after insistence by the registry. And then also you did not correct it. You didn't put the signature of your signature in the memo of appeal, in the what you call the wakalatnama.
In fact, everything is happening in hurry. Your Lordship.
Hurry happened, understood. The order was passed in the month of October 2023. You had 3 months? Did you have 3 months or not? You filed it on 15/12/2023. Okay, very well. Then you took it back and after insistence, you have returned on 6/2/2024. Then, till then, why didn't you correct it?
I have informed the filing section that my case file was misplaced. I have informed the filing section
What?
regarding misplaced.
Did you apply for against certified copy? Did you apply for a certified copy? You misplaced it, assuming even on 6/2/2024. Did you apply for a certified copy thereafter?
It is misplaced file. That one I
Did you sign the wakalatnama thereafter?
no. Actually, I have submitted earlier.
Did you sign the wakalatnama thereafter? No. Then? Now tell me, this is okay. I'll dismiss it, whatever may be. Why your name should not be sent for an inquiry to the Bar Council?
So, to be honest, I have.
That is the reason why I've asked
yes,
you to
Lord.
put an affidavit.
Yes, Lordship. I have humbly and respectfully submitted.
There's no other, there's nothing out there.
Submitted.
You are suffering from diabetes?
Yes.
Since how long?
Sir.
You must be knowing, therefore, the spelling of diabetes. See, what is the spelling you have put? 3-4 years you know, have a disease, you don't know the spelling also. Yes. DIBETES. और फाइल उसमें नहीं था. You couldn't sign this wakalatnama. Even after appearing for 4 dates out there before the Lozima court.
Actually, Your Honor, I have not gone through the case report. I have not gone through the case report before the Lozima. It is, I have submitted orderly and it was considered what
Who went?
before the Lozima.
Who went? Who went before the Lozima court?
Recently, when it is placed. What?
When did you go? With various orders on 7/2/2024. Makes it clear that somebody has appeared on behalf of Bill. Or you are the only person. Then you have a copy of the order passed by the learned appellate court?
Yes.
Show me. When are you providing the car space?
Yes, Lord.
We are concerned with the car's parking space.
It's dispute on the parking space, you know.
When are you providing the car parking space?
You know that it is in dispute, you know.
When are you providing the car parking space?
I could not understand you.
When are you providing the car parking space to the respondent in the appeal?
He is keeping his vehicle there, you know.
Have you provided it?
Yes, he is keeping there.
Have you provided it in written?
No, no. Against that order, I have come before this Lord.
Have you provided it or not?
What's the outcome of this appeal?
We have, so we dismiss it right away. You have this certified copy of 2000. You got this certified copy on 16/10/2023 on the date on which the order was passed. And you have not enclosed this. You couldn't enclose a photocopy. This is a high time, I think. This is a serious thing. You have to be sent to the Bar Council. No. This appeal.
Last chance will be given. Last chance will be given.
For what?
I will.
No. Your conduct does not inspire this court.
Lordship,
Your license has to be suspended for minimum 1 year.
Lordship,
No.
normally.
And I will further draw contempt against you for making it a false affidavit. When you are saying on this affidavit are there, and you have this certified copy on 16/10/2020. Draw contempt. And then think what further punishment can be imposed upon you.
Lordship, when we file the case.
The next thing is going to jail.
Normally what happen, your Lordship?
When you can
When we file appeal, we give all the documents to the clerk. And it is hurried, it is missed out, your Lord.
Who is the clerk?
Clerk in
Who is your clerk?
RC Lahekar, Lord.
Huh?
RC Lahekar.
Hello? We dismiss this appeal. Because as of now, we can't take it up. There's no wakalatnama. There's nothing.
I may be given some time to correct your Lordship as per requirement of the
Hello?
and all.
We'll take it up tomorrow. Correct it.
Friday.
Tomorrow. We'll take it up tomorrow. Tomorrow is Friday? Tomorrow is Wednesday. Tomorrow is Friday. Okay. We'll take it up tomorrow. 20.
For correction, Lord.
Yes.
My Lord, kindly take 2 p.m. I will correct at the daytime. Lord.
What?
For correction, bringing the everything on the record, kindly take the matter 2 p.m. Lord.
At 2 p.m.
2 p.m.
Tomorrow? Yes, tomorrow. I keep this thing and put it here. The learned counsel appearing on behalf.
That is required to be enclosed with the appeal, Lord.
Don't worry, I'm putting it and closing it now. Don't worry, with this, it is done. Now you sign this wakalatnama in my presence. No, direction.
I will bring all the.
Sign the wakalatnama in my presence. My goodness. And did you inform the RERA authority that you have filed an appeal before this court?
Yes, Lord.
And because of that, the RERA has stayed it? Do you know that?
No stay. No stay is there, Lord.
The RERA.
No stay is there.
No, RERA is not proceeding. The RERA authority is not proceeding because you have stated that you have filed an appeal before the High Court. Mr. Shah, we have also practiced. Don't think that I have become a judge from a district court.
I have
Then, don't try to take us for a ride. Sign it. What did you write out here? Within honorable court?
it's today right. Before the court, I have.
Tomorrow I'm taking up this appeal at 2. You prepare a substantial question of law.
Right.
Normally it should have been included in the appeal, but that is not there. So under such circumstances, bring that by another thing. Okay. Now, during the course of the hearing, the learned counsel appearing on behalf of the appellant has rectified the Wakalatnama so file by putting his signature before this court in the Wakalatnama, and also placed before this court the certified copy of the judgment and order dated 16/10/2023, which have been assailed in the instant appeal. The said certified copy is kept on record, taking into account that that is one of the defects which was duly pointed out to the petitioner appellant. But the appellant, the counsel for the appellant, for reasons best known, did not place it. This court have also taken note of section 58 of the what act? 58 of the RERA.
Yes, it was the real state appellate.
Of the Real Estate Bracket Regulation and Development Act 2016, which mandates that the appeal under section 58 has to be decided in accordance with section 100 of the Code of Civil Procedure, who's taking into account the learned counsel appearing on behalf of the appellant submits that the matter will be taken up tomorrow, and he will submit during the course the substantial questions of law which arises in the instant appeal. List the matter tomorrow at 2 p.m.
Highly.
You can record it. Give you a photocopy. Is this the Topsem matter?
Yes,
Topsem one? Yes, what happened?
May I please, your lordship?
Hmm.
Lordship, I'm willing to take time, lordship.
Huh?
On behalf of Mr. A. Kalita.
What happened?
Lordship, he is not keeping well, lordship.
Hello? When do you want it?
Lordship, after a week, next Thursday. Means,
Next
next week,
Thursday, not for.
on 28th.
You have filed your reply?
Yes.
Your reply has not come on record. When did you file?
14.
Oh, it is not on record. 14-3. Okay. Huh? Mention করা নাই নাকি? It is there. এটা কি? No. এটা কি?
Two affidavits we have filed.
Mention নকরেনি?
We
If you
filed two
want-
affidavits in respect of.
I've seen it. Mr. So-and-so, the learned counsel appearing on behalf of the standing counsel of the Lekho. Mr. So-and-so, your name,
N. Kalita.
appearing on behalf of the standing counsel of the industries department, submits that the standing counsel is not keeping well, for which he has sought for an accommodation. It's the matter again. 2nd of April.
Obliged.
Timeline.
May I please, Lord? Lord, today the petitioner filed additional affidavit, my lord.
We filed earlier.
Today I received.
Huh?
Today I have received another affidavit, my lord. So let me allow to file affidavit in opposition. Today-
What is this
Today-
filing after one
today-
after
today
another?
received.
The analysis of the documents which was supplied by us. Nothing new has come.
Now question is, so far one document, annexer 1, and another new, my lord, plea taken regarding the correct spelling of Kolkata, and somewhere it is written as Kolkata. And some document, my lord, relied upon regarding
All documents prepared by us.
regarding, my lord, retrofitting, my lord. So retrofitting,
You are appearing for Purbanchal,
I am appealing for respondent 5.
Azauddin. Your allegation is against Azauddin?
Yes, Lord.
Yes, now in this affidavit, my lord, raised, my lord. Earlier raised against respondent number 3.
No, I raised against both. all
But
pro-
here today, my lord, this appear respondent 5 regarding retrofitting award. Otherwise, my lord, so far my affidavit in opposition. There are good. Otherwise, my lord, so far my.
Yes, madam, why didn't you serve him a copy?
Lordship, it was a mistake. I served him this morning. It was a mistake because I didn't bring any new facts. Or Lordship had only asked me to analyze it and place it before Lordship on it.
Understood, but a dangerous statement you have made out there.
Now saying I enter agreement, but I have not entered any agreement.
Dear Lordship, it is
New-
dangerous.
Because if I
2.8.
dispose of without taking into account that page 259, Roman 5, it categorically says that this document on which the respondent number 5 has been taken is not an authentic document.
Absolutely, Lordship.
Then I need to. Hello. Mr. K.U. Ahmed, the learned counsel appearing on behalf of K. Bhuiyan,
K.
appearing on behalf of the learned of the respondent number 5, submitted that he has received a copy of the affidavit filed by the respondent petitioner
Today,
only today, and there are various allegations for which he would like to submit a short reply.
Yes.
Taking into account the above, this the matter again on 4th of April 2024. In the meantime, the reply be filed.
I would like to reply. On number 20, all have been served bids.
Let them reply.
Both here দুটা নাম দি দিব। Each Betala for respondent number 3 and he for respondent number 5 submits that they have received copies of the affidavit filed by the petitioner today and would such like to file a short reply. purpose of taking into account above this came on 4th of April 2024. In the meantime, the said replies be filed by 2nd of April,
Hi, Lord.
with it, copies being served upon the concept of attendance as well. You give it to them also. Huh? Don't be stingy enough not to give a copy.
That was a mistake, genuine mistake. Because some of them didn't appear. So the clerk was
Yeah, both of them have appeared.
It was
No,
the last
also,
day,
those
that
are
was
the-
the first time.
But Lordship, now it seems, if retrofitting is taken into account, they took retrofitting for them, not for me. I am higher, Lordship, than the two others who got the approval. Everything is in a mess, Lordship.
Because at point I would clarify it was first the application was on the certificate. The amount which they have taken into that was, that is the wrong clarification.
But that's the affidavit given by the
No,
state.
that is the affidavit that is stating a problem, but they
They
clarify
given by the
everything. So even her consideration.
We
was
have
the
to
right.
understand what Jalbor understands. And Jalbor understands the retrospecting of the petitioner was not taken.
Absolutely. That's the statement of order.
It's for 5 years, na? The contract is for?
5,000 connected, 5,000 each into six persons. Ultimately, it will be 30,000 total.
Done,
How are doing it?
completed.
Six are already selected. As they were allotted, their work is going on.
They're not completed. My information.
Not completed.
About to come.
Not
Hello, wait, if it is about to complete or completed, show me the completion certificate. I'll make it infructuous then.
Highly aware.
Yes, any solution? Yes, any solution?
My lord.
No, if there is no solution, there this court has to pass order,
Yes,
which will
Madam,
make
I
it more difficult.
In fact, I am deeply obliged with your lordship and consideration that lordship has given a handle, at least, my lord, on behalf of the state. Otherwise, if it is taken on merits, my lord, it will, my lord, entail
You'll have
severe.
You'll be very difficult later on. for you.
Now, my lord, what has happened? Yesterday, I had a talk with my learned colleague. He says, my lord, because in between, lordship has fixed the date on 1st of March. 1st of March at 11 a.m. They will go and approach the office of the deputy commissioner. Now, my learned colleague has told me that in fact on 1st of March, the petitioners, they went to the office of the deputy commissioner, and no one in the office of the deputy commissioner had given them a meeting, right of meeting. So I had inquired with the office of the deputy commissioner, and I had also called all the revenue staff. And they say, my lord, nobody has turned up. This is how the matter is. Otherwise, my lord, the people out there are ready. They are ready with the record. They are ready with to negotiate the matter with the
So we
petitioner.
make Mr. Arba Pujari the mediator.
No, my lord.
Better, then you can help get hold of both of them. You are in connection with him, and you are the main person.
My lord, I am
Something has to be
representing.
done. One side says that we went, nobody was there. Other side says that nobody came. How do I do it?
My lord, in fact, we were denied an audience. My junior had also gone. They did not know anything about it. We had filed an application. The DC was not even present. We moved and
After this order passed, then also the DC was not
no,
present.
he was busy elsewhere.
No, I
Therefore,
think we should have the audience of the DC then.
then there was this district development commissioner. He received a keynote. Then he called back last Wednesday, my junior, and he says that he is clueless about what all is this. What is this. And we also moved. We had also furnished the order.
This fact of the matter is not known to me.
No, this is not done. When this court had directed
Absolutely.
15 days back to
Absolutely.
the district commissioner, at least he should have given them an audience.
Absolutely.
The district commissioner not being there, it shows that he is not giving regard to the court. I think better off we can have a place emptied out here so that the district commissioner comes out here and hears him. If we are now to see so much in minute detail as to how the DC is not giving a audience even if after an order being passed by the court.
Absolutely.
What is the name of the DC?
You see now is Kitty Jalli. Kitty Jalli.
Huh?
Kitty Jalli.
I think better off we should have an audience with him.
Otherwise, my lordship, what I would respectfully submit, if lordship may be pleased to refer this matter to mediation.
Where?
My lord, mediation by the High Court Mediation Committee.
What are they going to do? That is not going to happen. This mediator has no, can't do this. The DC has to understand the basic thing. There has been a mistake committed by these authorities.
Absolutely, because now
On one hand, what the mistake they have done is that particular land of yours, them where they are in possession, that particular land has been not given to them, and whereas they are in possession, some other land was given. Now, on the basis of that other land being given where they have not claimed anything out there, you take up an action of auction sale, and then auction it, sale it. That means he have no land. But what happens to the petitioner? The only way out is to make as the petitioner is in possession of the other land.
Absolutely. I have personally persuaded the authorities.
But they are not agreeable.
Lordship, now, my lord, what happens, my lord? Lordship will kindly accommodate, if lordship may be pleased, gracious enough to accommodate the authorities with a stricture for a last action, my lord, chance that they will.
Because mediation can't help it.
Yes.
Either this court has to pass strict orders to
Yes.
the effect.
Now, if my lord, if absolutely, if the
No.
petition
Pass
is
the
decided,
order that this mistake has been done, and then the question of compensation has also to
Yes.
be given to the petitioner for being deprived of his use on occupation for all this while. And this amount should be taken as the value on a requisition basis, rental value of the land for all this while from such and such date. And thereby the payment has to be made from the salary of the deputy commissioner who has done that. This deputy commissioner should be given, he must be being more busy in some other matters. So here he does it. I think this deputy commissioner should pay from all that, the compensation. This can't happen like this. When this court has categorically passed an order, this is the way the deputy commissioner, district commissioner, they deal with. This order must have been given, Mr. Dekka.
yes, I have also, my lord.
And then the deputy commissioner doesn't give a scant regard to this court.
My lord, they say, my lord, that I don't know, my lord. I will have to seek instruction on this, my lord, that application, whether that application was received, my lord. Because yesterday evening, when I had a discussion with my learned colleague, my lord, this aspect of the matter was not made known to me, my lord. It is only just now I have come to know that they had filed an application. Otherwise,
Anyways, Mr. Barbadar, you were very much present on that day.
I had communicated.
Did you communicate this order
Yes,
to the
yes,
deputy commissioner?
Yes.
Then on that day, was the deputy commissioner present? File an affidavit on. This can't happen like that. And if he was not present on that day, let the deputy commissioner file an affidavit as to whether he was present on 15/2/2024 at 14. At 11 in his office. Let him file an affidavit.
1st of March. Lordship
First
has
of-
to- yes,
1st of March, 11 a.m., whether he was present in a court. And if he was not, and you have duly communicated him, we will draw contempt. See.
Otherwise, no.
There is no otherwise. This is something which has been done on the face of it. It shows there is a scant regard to this court orders, which this court is not going to do. For me, this is a good case for taking up proceedings on the 215th sumoto and thereupon take up action.
No, if I may pray, my lord, with all humility. If
Huh?
lordship, with all humility, if I may
There's
pray.
nothing out there. First of all, do you tell me, did you inform this order to the
Yes,
deputy?
yes.
That matters. Then also he has not given regard. Let him file an affidavit whether he was present on 1/3/2024 at 11 a.m. or did he inform? Because he should have then filed an appropriate application before the court that he would not be persuaded. This court, by an order dated 15/2/2024, taking into account that on account of the various illegal, on account of the fault of the respondent authorities, the petitioners have been deprived of the due land. And further, also taking into account that in the meantime, the respondent district administration have also taken action in respect to the land which ought not to have been further taken action for auction sale in respect to the land which was retained in the name of the petitioner. And thereby had created third-party rights. Was of the opinion that if the matter could be resolved amicably, taking into account that the petitioner presently is in possession of a patta number, what is that patta? Huh?
9,
Patta number 9, NK patta number 9, and the village needs Sinduri Bhopa. Gave a scope to the respondents to amicably resolve the issue. For which this court specifically on the submission of Mr. R. Borbujari, the learned standing counsel for the Revenue Department, directed the petitioners to appear on 1/3/2024 at 11 a.m. before the District Commissioner Kamrup Rural at Amingaon for a discussion of the matter. Mr. B.D. Dekar submits that as per his instructions, the representatives of the petitioners, the representatives of the petitioner duly went to the office of the Deputy Commissioner, District Commissioner Kamrup Rural on 1/3/2024. However, the representative of the petitioners were not given an audience. He further submits on instructions that even the District Commissioner, Kamrup Rural, was not present in his office. And there was
District Development Commission.
And some District Development Commissioner looked into the said application as well as the order and closed therewith, and informed the representative that he does not know head or tail about the said matter. On the other hand, Mr. R. Borbujari submits on instructions that no representative of the petitioner had gone to the office of the District Commissioner, Kamrup Rural at Amingaon. It is as it may, this court would like the petitioner to file an affidavit stating placing on record those facts as submitted by the learned counsel for the petitioner, and also would require an affidavit from the District Commissioner Kamrup Rural as to whether he was present on 1/3/2024 at 11 a.m. in his office. The district commissioner, Kamrup Rural, is also directed to state in his affidavit as to whether any representative of the petitioner had appeared before him on that date. To list the matter again on 1st of April 2024 for further consideration. শুনিছিলো জানো মই এটা যে জাজমেন্টৰ কাৰণে লাগিছিল শুনাই মইতো আগৰত
Sir, this is impugning the order dated 1/13/4/2009, passed by the civil judge Budri in title appeal number 7906, thereby allowing and reversing the judgment and decree dated 13/10/2006, passed in title suit number 183/96, passed by the learned
concurrent.
reverse up.
Yes. Your only point is point of determination not framed.
Yeah.
Under order 41 rule 31. Then is that an illegality? Is that a substantial question of law?
Yes.
Is it? How?
Hello.
How it will be? Yes, some
All the issues is to be discussed.
Hmm?
All the issues is to be discussed.
why?
Whatever issues has been framed by the learned trial court, the appellate court is to discuss those issues.
Is it required? Is it required for discussing all the issues?
No, there is. Forty-one, 31 contains date signature of judgment. The judgment of appellate court shall be in writing and shall state the points for determination, the decision thereon, and the reasons for the decision. Where the decree appealed from is reversed or varied, the relief to which the appellant is entitled.
Why are you saying that all the issues are to be discussed? Where is it? The appellate court has only to frame the points for determination.
But he has not discussed.
So,
He has not discussed.
kindly see, both parts, I've heard, I've gone through the rival contention, the admitted position is that so and so, the learned counsel of so and so, so and so, so and so. Now, the crux of the dispute is whether the appellant is a trespasser since 1994 as alleged by the respondent or is an unevictable tenant as well as. That is the point of determination. Page 10.
Yes.
Then one has to write, give a heading. Is this the mandate of law?
No, whatever the points of
That is the point of determination,
no, but
isn't it? Whether the appellant is a trespasser since 1994 as alleged by the respondent or is an unevictable tenant as alleged by himself. In fact, this is a better point of determination framed. Normally, what is being framed is whether the learned trial court's order is legally sustainable. This is a much clearer point of determination framed. You don't have a case, then that is the substantial question of law.
No, but other points where
There's no other substantial question of law.
but there is also scope that the other substantial question of law can be heard in the order. Then the
Order is okay. I would not permit. Matter ends there. 2009 matter too. Why should I? What other parts from substantial question of law remain? Let us see section 100. The appeal shall be heard on the questions of law so formulated, and the respondents at the hearing of them be allowed to argue that case and does not involve such question of law. Well, why should I permit you if that substantial question of law not framed? And if I have to do, I have to again reformulate and give them an opportunity. I can't frame it now. As of now, there is order 41, rule 31 has been duly followed.
So what the mandate said, there is otherwise expressly provided in the body of this court or any other law for the time being in court, and appeals the like to the High Court bench.
And to number 5, 105.
Yes. The appeal shall be heard on the questions of formulated, and the respondent shall at the hearing of appeal be allowed to argue that case does not involve such question.
Then why should I allow?
If you not
Your only question was 41 rule 31, and it is there.
if you not see, there is the
You are to therefore your second essential question of law at best be a case of perversity. What is the perversity? Show me.
adversity is whatever, if your lordship kindly, there is the judgment.
What is wrong?
My lord, page 9, I will start.
Hmm.
The learned counsel so for the appellant while wrestling the interim judgment has argued that the appellant has been possessing the suit land as tenant since 1967. There is presumption as to the correctness of the revenue record.
Paragraph? That's the only thing I think there is no paragraph out there.
Yes.
Where? That would not be a substantial question.
Page 9.
Yes.
Decision and reason.
Ah.
The
No, that
learned-
is a submission.
Submission.
While extailing the impugned judgment as argued that the appellant has been possessing the
No.
land tenant since, and there is a presumption as to the correctness of the
My lord, page 10, para 3. Started.
tenancy and challenge the burden lies on the public who challenges. Suit was for eviction.
Suit for
And his case was that he was a non-evictable tenant.
Yeah.
Did he have a right? Right Ekotian.
no. His right Khatian was
And that has
cancelled by
been
the
said to be
landlord.
proved at page 12.
Yes.
Exhibit 1, note 1 of exam recorded so and so. It has been mentioned that as per the order dated demand of the ARO under section 107 of the GT and in pursuant to the order of the DC, the Khatian was issued rent payment receipts, exhibit 2 to Iman dependent site and these documents, although not the title documents yet, they can be read in evidence if not rebutted. So, what are these?
My lord, his Khatian was cancelled, and against that cancellation, he has not went to any superior.
When did you give an evidence to the effect?
Yes,
Where is your evidence?
if the lordship go to the trial court judgment.
It is there in the trial court judgment
Yes,
that his Khatian was cancelled.
yes.
Let us see. Where?
Case 15, my lord. Lord part, the defendant along with his men in the last part of 94 possibly and illegally disposes the plaintiff from the remaining part of the schedule land, which is described in the schedule E. The plaintiff raised objection against the order of the ASO, pro forma defendant report. He rejected the order of ESO and record was accordingly corrected in the name of the original patata. Now the plaintiff has filed the suit for decreased transfer. Then, my lord, issue number 456, page 20, my lord.
Where?
Page 21, judgment. The plaintiff in support of their case has exhibited sale deed number so of the plaintiff. On perusal of the exhibit 1 of the plaintiff, it appears that 4 sons of the late Aizuddin Poddar sold the land measuring 10 biga 1 kata 13 to the plaintiff. Exhibit 6 of the plaintiff side, which is the order of the settlement officer, clearly mentioned. The name of the defendant was subsequently inserted, and accordingly, the same was liable to be cancelled. The defendant did not prefer any appeal against the order of the settlement officer. Exhibit 4 and 5 of the plaintiff side shows that the name of the defendant was cancelled as per the order of the settlement officer.
Where? You are reading which page?
Page 20.
Where is it? No, that is your submission.
No, then
Where is it? It was cancelled. Page 20, where is it? Subsequently inserted and according the liable was same is liable to be cancelled.
Yeah.
Has it been cancelled?
Yes.
Where?
Exhibit is there.
It is not recorded in the trial court judgment.
Yes, it is the record. Page 22, my lord. Page 20.
Yes.
Second paragraph. From the above, it is clear that when the name of the defendant was cancelled by the order of the settlement officer by exhibit 6 of the plaintiff side, the defendant disposes the plaintiff from the suit land and obtains the order of status quo from the executive magistrate court. Exhibit 9 of the defendant. This order was passed during the pendency of the suit. Therefore, from the above discussion, it is clear that till 2003, the name of the Aizuddin was recorded as Rayat. In the year 83, his 4 sons sold the suit land to the plaintiff. In the name of the exhibit 1, the defendant has already been cancelled by settlement officer. And the defendant, instead of filing an appeal against the order of the settlement officer.
Wait, Mr. Jain, we formulate another additional substance and then we'll hear the matter. During the course of the hearing and upon a perusal of the impugned judgment and decree passed by the learned First Appellate Court, it is the opinion of the court that the first substantial question of law, so framed, so formulated, does not arise inasmuch as there is a point of determination which have been duly framed by the learned first appellate court. So, be it as it may, during the course of the hearing, this court found that a further substantial question of law can be formulated which is as under whether the learned trial of first appellate court was justified in decreeing the suit without taking into account exhibits, whether the judgment of the learned first appellate court suffers from perversity for not taking into account Exhibit 6. Exhibit 6. Whereby I'll speak with. Exhibit 6. Suffers from perversity in view of non-consideration of Exhibit 6. This is the matter again on 2nd of April 2024 for further hearing of the appeal. Mr. Ali, your judgment I was to deliver today. I could not. I'll do it one thing. I'll do it on 2nd of April. 2nd of April.
2nd of April for judgment.
Not for judgment, I'll dictate it in your presence. On 2nd of April. Because today, next week, almost close. 2 days are there. And it's very difficult. One Thursday, I can have it on Thursday. Thursday, I've got many more matters. No?
Next Thursday,
Next Thursday, there will be a lot of matters. Otherwise, also fixed. We'll have it on 2nd?
2nd of April.
2nd.
It will be listed as
Top of the list. In fact, I asked him to give me that matter only. He gave me his matter. Because his matter was...
it's still time, your lord.
No, actually, I have to rise. I have some meeting today. So I'll have to rise. Otherwise, I would not have said that. I'll have to rise. I will take it up on 2nd.
Top of the list as first item, your lord.
Top of the list, it will come.
Because there are a number of top matters in top of the list.
No, those top of the list were fixed earlier when I was taking bench 4-5, and therefore those matters came in. Now, at that point of time, I never thought that this will happen. Now, what has happened in the meantime, there were a lot of FAOs. Unnecessary FAOs were pending out here. So those have been brought in out there to finish it up. The top of the list, take it a minute.
One prayer. 12. 12 also be kindly fixed on.
Which item 12?
Item 12 hearing. 6.9.
Item 12. These matters will come. I have not heard these matters. No? I will take up this matter. Mr. Ali's matter is this, na? 4. Item number 4. 4, top of the list on 2nd. এখেতৰ মেটাৰটো পাৰ্থত হিচাপে লেখাব লাগে এইটো
And